All eyes this week, of course, have been focused on Manhattan District Attorney Alvin Bragg's office. Is he going to indict Trump? Is he not? Is it Tuesday? Well, it didn't happen Tuesday. Is it today? Is it going to be Thursday? We don't know. We don't even know if it's going to happen. But while we've all been hyper-focused on what's happening in Alvin Bragg's office, we've overlooked something very, very important that could end up being far more damaging to Donald Trump. On Monday of this week, reaffirming a previous ruling from 2 weeks ago, U.S. Judge Lewis Kaplan ruled that in the E. Jean Carroll assault case that is going to trial on April 25th next month, the prosecution can, or plaintiff's lawyer, because it's not a prosecution, the plaintiff's lawyers can play that infamous Access Hollywood tape, and they can call in 2 witnesses who also allege that Trump assaulted them. Now, Trump and his legal team had been fighting for quite some time to not only restrict the Access Hollywood tape from being played, but also from restricting the 2 witnesses from coming in and talking about their experiences with Donald Trump. His lawyers went to court and had told the judge, listen, this isn't part of this case. You know, none of this is relevant, so why would we allow this to happen? But the judge said this week, there is no reason, and Mr. Trump has made no persuasive argument for me to rule differently. And here is why this is so important. With E. Jean Carroll's assault case, which I know by now everybody knows the story, early 90s, Trump allegedly assaulted her in a Bergdorf department store dressing room after the two had been kind of lightly, I guess, bantering, flirting almost back and forth. Trump escalated it, according to her complaint, and assaulted her in the dressing room. Now, there's no evidence from that day other than DNA left on the outfit that she was wearing. Trump has not given up his DNA, so we can't use that to prove that it was him. So other than that, it would be her word against his. Well, especially in cases like this, that's going to be very difficult for the plaintiffs to secure a victory. So what the plaintiffs have to do is they have to establish a pattern of behavior with Donald Trump, showing that, hey, it's likely he did this thing in the 90s because this is how he's operated forever. But in order to do that, they have to be able to play the Access Hollywood tape, and they have to hear from these other women who allege similar things happened to them. If they didn't have that evidence, honestly, I would say there's no way they could win this case. Just based on evidence alone, okay? I'm not saying I don't think Trump did it. I think he did it. I believe E. Jean Carroll, 100%. But could I prove it? Could a lawyer prove it in court without all of this other evidence and these other witnesses? The answer to that is no. But now that this is allowed in, that increases the chances of a victory for E. Jean Carroll. This is a massive, massive ruling. And it is interesting because, like I said, about 2 weeks ago, Kaplan also ruled the same thing again. So this was another ruling, a separate ruling, reaffirming the first ruling, but also, by the way, and this is exceptionally damning to Donald Trump, separating the defamation lawsuit from the assault lawsuit, because originally they were going to tie them both into one, and the judge said, oh, no. Let's do these separately. Let's make him go to court twice. Let's make him sit through this crap 2 times instead of 1. So yeah, Donald Trump is having a very bad week, legally speaking, but some of the worst things happening are the ones that aren't capturing the headlines as much as what's happening with Alvin Bragg's office. This is Hattie. Hattie wants to know why you have not subscribed to our channel. You obviously like our videos, so do us a favor and subscribe.